So you have brought a claim to the WRC or the Labour Court and you're representing yourself. If that's the case, and if you're to have any chance of winning, you will need to make a submission. The question of when you make the submission is up in the air insofar as there's different views as to when you should actually put your submission in from a tactical perspective. But the fundamental point is, if you are to win your claim for unfair dismissal or any other breach of an employment right, then you will need to make a submission, and it will be need to be sufficiently persuasive that you win your case. If you are a lay litigant, if you're representing yourself, if you're doing your own thing, you've submitted a claim, you're going to the WRC or the Labour Court yourself, which you're entitled to do, then you may well run into a legal team for the employer. Whether you do or not, in any event, you will need to make a submission. How do you do the submission? Broadly, I think there is a sort of a pattern, a template that you'd want to follow, and you need to tick a number of boxes. But the two big boxes you need to tick are: one, you need to prove the events that give rise to your claim and prove your story, prove the wrong that was done to you, as it were. And two, you need to prove the law. The law is on your side, is in your favour, and therefore the adjudicator or the Labour Court must give you the decision that you're looking for. So the two broad categories: prove the facts, prove the law. If you can do that, you should win. If you can't do that, you'll probably lose, and that's the reality of it. I would suggest, and I've seen plenty of submissions, I've done plenty of submissions, and I'm doing them there at the moment, the submission should probably look at or contain four broad sections. One would be the background information, basically explaining to the adjudicator, and I will say for the sake of this video that it's a WRC hearing, explaining to the adjudicator how the issue or dispute arose, how the claims have arisen, a brief look at who the complainant is, you, the employee, who's the respondent, and how the claims have arisen. So that's the background. The second section or second part of it, I would suggest, is the facts, the narrative, the events, the evidence that will prove your side of the story and prove the wrong that has arisen. So you need to prove the facts. You need to show evidence or draw upon evidence which will support your version of events, your side of the story. And remember, in any situation where there is a conflict, there's going to be an adversarial situation to a certain extent, insofar as your story will be one story, the employer will have a different story, and the adjudicator then will have to decide whose version of events is the most credible, whose version of events is the most likely to have occurred. So that's proving the facts. The next step you need to, in the broad category, broad section of your submission, will be you need to prove the law. So you need to look at the legal position, you need to look at the relevant statute that is what you are relying on to prove your claim, to prove the breach. So if you're saying that a particular statute, for example, the Unfair Dismissals Act 1977, says that the employer must have substantial grounds for terminating the employment, well, in that case, then the employer must prove that they have substantial grounds to do so, and you are going to set out the law in that area. You're going to set out some case law which will support your contention that in this case the employer did not have substantial grounds, and so on. So you'll be looking at statute, you'll be looking at case law, you'll be looking at decisions of previous adjudicators, Labour Court, and indeed Civil Court. And that's where the section where you're going to be basically proving the law. And finally, then there's going to be a conclusion or an ask. You're going to be asking the adjudicator, in the event that you're successful, what remedy you're looking for. The adjudicator will have a fair degree of discretion as to what remedy, but the remedy, or may have a fair degree of discretion, but the remedy will be provided for in statute. And in the Unfair Dismissals Act, for example, it could be compensation, it could be reinstatement, it could be re-engagement. So you need to let the adjudicator know in your conclusion basically what you're looking for, and essentially that as far as you're concerned your claim should succeed, your claim is well founded because you've proven the facts and you've proven the law. That, I think, is the broad template. 4 sections: background, prove the facts, prove the law, conclusion. That is the broad template I'd be using in relation to making a submission. The number, when you draw upon, just as a matter of clarification, when you're proving the law, you will be making reference to statute, and you will be making reference to case law, decided cases, and you will have to probably put in some of those cases as supports for what you're arguing for your proposition. In other words, authorities for the proposition that you're making. So you will need comprehensive exhibits or appendices in your submission. So you'll have your submission, 4 sections, and then you'll have your appendices, which may include, for example, the contract of employment, may include an investigation report, may include a disciplinary outcome, may include the various cases on which you are going to rely as authorities for the proposition that you're putting forward. Anyway, I hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below. Thanks a lot.